Enrique Leon against U.S. Precast Corporation and FCCI Mutual Insurance Company.
May it please the Court, my name is Bill McCabe. I represent the claimant Enrique Leon. I'll reserve 2 minutes for rebuttal. In this appeal, the Judge of Compensation Claims entered a summary final order, which is what they call summary judgments in workers' comp, in favor of the employer carrier, in which she ruled that the settlement documents entered into between the parties did not entitle the claimant to past medical reimbursement. And of course, we contend that the judge's ruling is error.
And she did so even though the EC had withdrawn or abandoned its motion for final summary order.
That is correct, Your Honor. Both parties initially filed a motion for summary final order, and then at the status hearing before the judge made a ruling, the employer carrier specifically withdrew their motion for summary final order. The judge gave it to them anyway. And I acknowledge that the claimant alleged that there were no material issues of fact. I acknowledge that there's cases in civil proceedings that hold that a court can, even though it's not a preferred procedure, enter sua sponte, a summary final judgment in favor of the non-moving party. But I am not aware of any case, nor was any case cited, that holds that a summary judgment was entered. Actually, I couldn't find any case either way, but that a summary final judgment would be entered in a situation where the non-moving party actually filed a motion and then withdrew it. And so we submit that if...
But doesn't the rule give the JCC the authority to do that even without a motion?
The rule allows the judge to enter a summary final order, yes. But like I say, this is a situation where the carrier actually withdrew it. And the judge on page 31 of the record indicates that if she found no material fact and ruled for claimant, she would, but otherwise she'd set it for a hearing. She didn't indicate I might still rule for the employer carrier. So it's kind of a ruling that seemed to come a little bit out of left field. But we question the procedural aspects of the case. Getting to the merits itself, if this is a situation for a summary...
When you say you question the procedural aspects, you're not saying that that is the basis for the appeal?
It is one of the bases for the appeal, yes, sir.
Which point is that?
That's point one. Point one of the brief specifically challenges the JCC's entry of a summary final order in a situation where the employer carrier withdrew their motion. Getting on to the, if I may move forward to the...
It doesn't make its way into the statement of the point, but you're saying somewhere in the argument we'll find that.
I do argue that, yes. Particularly in the reply brief, too. Getting on to the issue of if it is appropriate for a summary final order, we submit that it should have been entered in favor of the claimant. There was a mediation settlement agreement between the parties that said the carrier is going to pay $52,500. It also stated that all past authorized medicals have been or shall be paid. It doesn't say it was not limited to just all past medical bills. It says all past medicals. Case law is very clear that medical mileage is part of medical. And there's two cases. There's the Sam's Club versus Bayer. I've cited in the brief Mobley v. Jack and Sons Plumbing, both of which hold that medical mileage is medical. Now, so the mediation agreement clearly entitles the claimant to the past medical mileage reimbursement. Now, the claimant did sign a general release, And in that, it did state that the carrier was going to pay the claimant the $52,000, actually said $400 because he was getting $100 and another thing, but the full amount of the money. And it didn't mention anything about medical mileage reimbursement. But when the claimant's attorney sent that general release to counsel for the employer carrier, it also included a request for the reimbursement of the medical mileage. It also included an addendum. It also included the 8 pages of mileage reimbursement. Now, we submit that the carrier could have done one or two things at that point. If they thought that the letter, the mileage reimbursement, et cetera, somehow altered the terms of the stipulation, they could have called the claimant's attorney at that point and said, what's this about the mileage reimbursement? And they could have hopefully resolved that issue at that point. We wouldn't be here. The second thing they could have done, which is what they did do, is they submitted it to the judge of compensation claim. Actually, not the agreement, because they don't have to do that anymore, but they did submit the attorney fee and child support documentation to the judge of compensation claims, who approved it. Now, we submit by doing that, they either agreed that the mileage reimbursement was in fact part of the agreement as claimant contended, or by their acts, a contract to pay the mileage reimbursement was deemed at the very least as a contract implied in fact.
All right, but when you discuss the first possibility of what they could do, that assumes that there was some ambiguity in the little package they got back with the release signed without any qualification and the other papers.
That's partly actually what the employer carrier argued. That's part of what they thought the ambiguity was.
And you would agree with that?
It seems as if there's obviously a disagreement as to whether there was an intent between the parties that to include mileage reimbursement or not. There's a little quip in the transcript at page 19 or 20 where the employer carrier's attorney contends that the mediation agreement is ambiguous. No. Yeah, ambiguous. Counsel for claimant says it's not, and then vice versa for the settlement agreement. So it does seem like there's obviously a disagreement between the parties as to whether the mileage reimbursement should be paid or not. It does seem to be some ambiguity in the record, but if there's not, if summary judgment was appropriate, then we submit that clearly the judge should have ruled in favor of the claimant, because otherwise the employer carrier didn't have to submit the papers to the judge. They should have called up ahead of time. This isn't a situation, if the claimant's attorney had done nothing but sign the general release and return it, and then after all the paperwork went through, then submitted the mileage reimbursement, then we'd probably be out of luck. But that's not what happened. The claimant's attorney submitted the mileage reimbursement at the same time that he returned the general release with a PS on the bottom of the letter, please submit for payment.
Well, my question is, are you free to argue at this stage of the proceedings that there is an ambiguity when the opportunity to make that argument below was eschewed, when the employer said this is ambiguous and the claimant took the contrary position and rested on the motion that asserted that there was no ambiguity?
Well, I mean, to be honest with you, I think that's a very interesting question. I mean, I admit in my reply brief that you're not supposed to raise an issue for the first time on appeal. And like I said before, I acknowledge that there's cases where a judge can enter summary judgment in favor of the non-moving party. But I haven't seen a situation, and there's no cases, where the judge can enter a summary judgment when the opposing party withdraws their own motion.
At that point, the opposing party becomes the non-moving party, don't they? When they withdraw that motion, don't they become the non-moving party?
Well, they are the non-moving party for purposes of the claimant's motion for summary judgment, yes. They were at all times the non-moving party. But when the non-moving party, I don't know, it seems like when they withdraw their motion, they're stating that there are ambiguous facts or issues of material fact that need to be tried. And it seems, I don't know, the judge is granting a motion for them that they basically told the judge they're not entitled to. So.
But how would you box yourself in filing your motion of summary judgment? And when you file your motion of summary judgment, you say there's no material facts, that you are entitled to judgment as a matter of law. You're saying there isn't any dispute as to any material facts. The JCC looks at the record and rules. However, in this case, and I agree with you, generally the JCC rule when there have been cross motions for summary judgment, the JCC will grant one and deny the other. But in this case, the ECC withdrew their motion. But if there's no dispute as to any material facts, and that is your position in the proceedings below, that there is no dispute as to material facts, haven't you boxed yourself in for purposes of appeal if the JCC finds that there is no dispute as to any material facts and then rules for the other side?
Well, I have to admit that it is problematic, but that's why I didn't limit my appeal to that one issue. I mean, I think that if it is ripe for summary judgment, as I've argued before, I think it should have been in favor of the claimant, not the employer carrier. I'll reserve the rest of my time for rebuttal.
Please the court, Your Honors. My name is Peter Egan. I'm here on behalf of United States Precast and FCCI Insurance.
Counsel for the appellant referred to the addendum that the appellant filed.
Yes, sir.
With the JCC. Didn't the addendum the appellee to the appellee's release agreement and the letter that the appellant filed with the addendum create at least an ambiguity with regards to the release regarding past unpaid and future medical benefits?
I knew you were going to ask me that question, Judge. That is the basis for some of the conflict in this issue. When presenting the initial information to the court below to the JCC, the timeline as offered by counsel is correct. The addendum was submitted at the same time as the washout papers were returned to counsel for the appellee below. However, as found by the JCC below Judge Pecco, the addendum itself was handwritten, and the documentation that backed that addendum, Your Honor, was not signed, wasn't initialed, and was not discussed between the parties at any point in time before it arrived on the desk of counsel below. The the general settlement agreement below was found by Judge Pecco to be an all-encompassing document pursuant to the terms of that document, okay, which was executed by the claimant, executed by counsel for the claimant, executed by the employer carrier, and also initialed by the claimant below on all points. And I would argue with the court, or I would state to the court, that the JCC below has to be given the deference to determine whether or not that document, the addendum specifically, is necessary to make a ruling on the motion for summary final order. As you indicated, Judge, earlier, with regard to the withdrawal of the motion for summary final order by the employer carrier below, it is my opinion that at that point in time, the employer carrier below, the appellee in this case, becomes the non-moving party. Now, it's clear in the case law that although it may not be preferred that a court enter a sua sponte motion, okay, it's absolutely clear, it is still permissible that the court do that.
Or does he argue otherwise in his initial brief?
No, Your Honor, I don't believe he does. However, a distinction is made that in this case it would not be appropriate because of the fact that there is question as to the intent of the parties. The motion for final order, as entered by the employer carrier, as filed by the employer carrier, which was withdrawn prior to ruling by the judge, made the allegation that the issue of material fact was potentially the intent of the parties should the court find that the documents controlling the general settlement and waiver were ambiguous. Now, it's my position, and it's the position of the appellee, that upon the finding by the JCC below that those documents were not ambiguous, the intent of the parties went away. It was no longer important to examine the intent of the parties because Judge Pecco, JCC below, determined that the intent of the parties was clear on the face of the documents. Something that counsel mentioned in his initial brief.
Well,
Yes,
here
sir.
you are taking the position up here that there was no ambiguity, even though you argued below that there was.
Yes, Judge.
Does that give you pause?
It certainly does, Your Honor, and I think both sides to this argument are in a position where they're now arguing opposite positions as they did below, and then myself and counsel are aware of
You're
that.
saying essentially that a judge has the right to disagree with the lawyer even when it's to the lawyer's benefit to be disagreed with, and that once that happens, you have a right to take up the judge's cause on appeal.
I believe so, Judge, but to answer the question directly, I think that the issue of ambiguity that was raised by the employer carrier below, again, was specific to the intent of the parties. Should the JCC below, if you reflect on the record and the dialogue that took place between counsel and the judge, should the JCC below find that there is an ambiguity in the controlling document here, the general settlement, okay, the intent of the parties may need to be considered. That was the basis for the ambiguity, for the argument of the ambiguity. The intent of the parties would create that ambiguity. Judge Pecco took all the evidence in front of her. She took all the documentation that was submitted, inclusive of the addendum, which she chose not to give credit to for the fact that it was not signed, not dated, and not properly executed. The mediation settlement agreement, which was the underlying document, as well as the general settlement agreement, which is the document that purported to include all terms of the agreement, as found by Judge Pecco. She took all that documentation and she, in turn, said, it's clear on its face. The natural language of the document, the language that is required is there. So there's no point to look at the parties. Pursuant to Patco versus Estupian, the plain language is the best indicator of the intent of the parties.
Now, you're not arguing that mileage is not
No,
part
Judge.
of what the EC are responsible to pay.
No, Your Honor, not at all. And as a matter of fact, in our reply brief, we did stipulate to the fact, and we did concede the fact that medical mileage is properly found to be a part of medical benefits. However,
What is there in this record to show that you have discharged that obligation?
in the record, Your Honor, if you look at the general settlement and waiver, which is, the general release, which begins at page 62 of the record. The terms of the general release indicate that, on page 65 of the record, that the obligations of the parties have been met upon the payment of $52,400. I'm glad you brought that up, Judge, because I was going to get to that in a second anyway. Using the logic that mileage does, in fact, constitute a medical benefit, okay, the general settlement as proposed by the employer carrier, as signed by the employer carrier, as signed by the claimant below, indicates that upon the execution of the document and the claimant's receipt of the lump sum, the claimant will release any and all future charges or claims. Now, further in the document, in the record, page 66, it's indicated in the allocation of the lump sum that at the top of the page, under item C, past and future medical benefits are payable in the amount of $20,000. Past and future. Medical mileage would be a past medical benefit. So it is contemplated within this agreement. To state that past medical benefits by way of mileage are due and owing on top of or beyond the payment of past medical benefits, non-Medicare covered benefits, is at issue with the agreement that was reached between the parties. Because it's our position that the document that was executed by all the parties and that Judge Pecco found to be a credible and non-ambiguous document did, in fact, consider and include payment of that mileage under the past and future medical benefits. If the cost of the medicals is taken into account, again, I believe it's necessary that you consider lump sum payment in the amount of $20,000, which is not contested that the claimant did not receive, included that documentation. With regard to an issue...
I'm sorry,
Yes,
what is not contested?
The claimant received payment of the lump sum settlement, Judge. that the payment was delivered to the claimant, the amount of $52,400. To address an issue brought up by the court previously, we believe that under Bill's Equipment Rental versus Teal, the site is 498 Southern 2nd 536, the failure to preserve an issue below waives the question on appeal. The claimant, at this point in time, the appellant in this case, is arguing a position that's 180 degrees from the underlying claim. Now, I realize I'm in the same boat, okay? But, again, to address Judge Lewis's point, I think by withdrawal of the motion for summary final order, I become a non-moving party. The employer carrier becomes a non-moving party and doesn't necessarily assert the fact that there are no issues of material fact. Just because a party says to a trial judge, Judge, I believe there's an issue of material fact, doesn't make it so. There has to be a demonstration of an issue of material fact. And I believe that Judge Pecco took into consideration all the documents and evidence that were presented in front of her. And we're not talking about a great volume of evidence here. We're talking about less than 50 pages of documents. Took into consideration all those documents and all that evidence and the argument of parties, and basically stated that she found the general settlement to be a non-ambiguous document. The intent of the parties was not necessary to be interpreted by any part.
Are you saying she made findings of fact before entering the summary final order?
I'm sorry, Judge?
Is it your position that she actually found herself making findings of fact before entering a summary final order?
I think, yes, Judge. I think if you look at the order, if you look at Judge Pecco's order, which begins on page 87 of the record, she does state that she makes, these are the undisputed material facts as follows. So I think from that statement, she does in fact make some material fact findings. However, I think those findings with regard to the evidence that's presented are within the purview of the court below and are within her jurisdiction to make those findings. I see my time is up. Thank you.
All right. Thank you.
I don't know how much time do I have left.
You have 1 minute.
Okay. As far as whether I argue this, the point one, the point itself says the JCC erred in granting a summary final order in favor of the employer carrier when the employer carrier withdrew its own motion for summary final order, contending that there was a conflict between an addendum, a settlement release, and a mediation agreement which created an ambiguity which required a trial. I think the issue is clearly argued. Now, whether on the grounds, well, was it raised below or not, review of a summary judgment order is de novo. So it would seem to me that this court has the ability to determine on a de novo standard whether the judge of compensation claims properly entered a summary final judgment in favor of the employer carrier in this case. And then as far as the actual merits of the case are concerned, the mediation agreement clearly contemplated 52.4, plus it had another paragraph, I believe it was number 5, that the carrier would pay past medical. The general release, if you take that document solely by itself, it would appear that the $52,500 covers everything. But the general release is not in a vacuum by itself. It came with a letter requesting mileage reimbursement, the mileage reimbursement, and an addendum. And when the carrier submitted the attorney fee document to the judge, he either accepted the terms of that letter or he should have called up the claimant's attorney and said, I'm not sending it because we have a dispute over mileage reimbursement. When he didn't do that, I think he confirmed, our argument is he confirmed the request for the mileage reimbursement. Thank you.
Thank you. We are in